plaint. Okay, they give you that plaint and they tell you, counsel, your defense counsel, you've been served with the pleadings, proceed. But when you take time and read the pleadings, they are defective. Now we should know what things make the pleadings defective. They'll give it to you one when the plaintiff doesn't disclose a cause of action. Automatically, that PO dismisses the entire suit. They'll give you when it lacks jurisdictions. Okay? When this person has sued a non-existing party, when the subject matter is out of time. Okay? So when you look at it, you know the implication that, okay, so this matter is time bad. Why should I defend a matter which is frivolous? Okay? That we are looking for this, they'll give you the plaint. So do you know how to deal with the plaint when you are the defendant? Do you know how to peruse the plaint? You mark out those important matters. Okay? Because now you studied particulars of a plaint, order 7 rule. That means once you are served with the plaint, all of those should be there. First look at it. Understand whether everything required is in there. Okay? Because if the contents are not there, order 7 uses the word shall, which is mandatory. So that means the suit has no. So how would you do? Okay? So make an application for security for costs. Now we presume that that is settled. But again, upon perusing, okay, the plaint, you realize that counsel has mentioned something which is not attached. You need it. How will you go on with it? Interrogatories, inspection, and discovery. Okay, because Article 28, you should be given sufficient time to prepare your defense. Because you want to prepare a reasonable defense. That's why you are looking at everything. Okay, so that you don't proceed in abstract. Okay. So now we presume that that is settled. You still have your time. Okay. So what happens where time has expired as a defense counsel? You apply for extension of time. So now we presume that now you've read everything. Okay. Then what kind of defense are you supposed to file? Then you got what we call types of defenses. We have a technical defense. Under what circumstances? They can also give you a plaint. They tell you, counsel, what defense can you file? They have given you, but when this plaint is defective, okay, so that means you have objections. Remember, technical defense is a defense with an objection. Okay, so now you have to read the plaint, you underline the objections you have. Once you see that you have objections, you have good POs, that means the defense you're supposed to file is a defense with, or okay, a technical defense, a defense with objections. It's okay. Okay. If not that, they'll give you that plaint. They add you some other facts of the defendant, where the defendant has a counter claim. Okay, so it's okay. I'm supposed to file a defense with a counter claim or a defense with a set of. So that they won't ask you, counsel, give us the different types of defenses. This is not primary. They find means of asking something you know, but in a very technical way, which requires you to think as a prudent advocate. Okay? But we are following the procedure. Okay? So now, at that point, also think they can give you different plaints. Okay? When the plaintiffs are different, when the defendant is the same, on the same subject matter, the tell counsel proceed. You start thinking of consolidation. Before you proceed, it's okay, they are against the same defendant on the same subject matter. So what remedy do I have? Am I going to be appearing in this one and also this one? No. This guy is assisting the same remedy. So let me make an application, we consolidate them, we proceed in one suit, or you go for a test suit, as the case may be. Okay? But all of those are remedies you exercise before the matter. Okay? So once you are given any pleading, take time, understand it. Okay? So now, we presume that you have filed whatever type of defense. Okay? You have filed. Then the other party has to do what? To reply within 15 days. Okay? So what happens where the other party has not yet replied and you realize that your defense is defective, you want to do something? You go for amendment without leave because you are still within your time. So now we presume that pleadings have been exchanged. All parties have exchanged their appropriate pleadings. But at that point, the plaintiff realizes that the plaintiff has a problem. What will the plaintiff do? Okay, an application for leave to amend. Because here you are out of time. You can't amend without leave. So you first make an application for leave to amend pleadings. So that means amendment of pleadings. Okay. Okay. So you ask yourself, we are looking because civil, they are not going to tell you that we are looking for remedies, but the entire course unit is full of remedies. If you don't know those remedies, you can't pass. That's the challenge with civil because they don't ask something direct. Okay. So now we presume that pleadings have been served. Okay. Again, they can ask a question where the plaintiff has served the defendant, but the defendant has not filed a defense at all. So you think of the remedy. Okay. Are you proceeding ex parte or you're making an application of a default judgment? Okay. You are looking at those remedies, but they can't tell you something direct. Okay. So now we presume pleadings have been duly exchanged, all those. So at that point, think of all interlocutory applications. Okay. All interlocutory applications. Because after exchange of pleadings, we go to what we call summons for directions. So ask yourself, do you know the law regarding summons for directions? Within what time should summons for directions be extracted? Who has the obligation to extract summons for directions? Okay, it is the plaintiff. Within what time? What is the effect of not extracting summons for directions? The matter will be paid. Okay. So at that time, you ask yourself, what are the different contents in the summons for directions? All interlocutory applications, injunctions, temporary injunctions, amendment, consolidation, test suits, security for costs, all those are interlocutory because those applications, you apply for them before the matter is set down for hearing. That's why when you look at Order 11A, it is very clear. Court has the duty to consider all interlocutory matters during summons for directions. Even if you've not asked for them, court has the power. That's why it's called summons for directions. Court can direct by force if they deem fit that it is applicable. So ask yourself, you have to draft summons for directions. Okay? So think about it. So we presume that summons for directions have been extracted. Okay? Once they are extracted, they are supposed to be served to the adverse party. The adverse party is supposed to respond within what time? Yes? 14, 15. 15 days. What happens where that person doesn't respond to the summons? Okay? You will read them. Okay? So now, we presume that the summons have been served and they have been complied with. Okay? So after you've complied with the summons, the matter goes to the next step known as the scheduling conference. So ask yourself, whose duty? Who has the duty for a scheduling conference? Is it the court or the parties to a suit? Should we read the act? Because I know the provision says court shall provide room for scheduling conference to have agreed facts, agreed issue and issues for determination. Non so. So why do you say that it is the practice? Because it's the practice. That's why I told you practice is different from what you people study at the back course. Okay, so mark that. Okay, so are we together? So what happens at that point? They can tell you, they can give you a joint scheduling memorandum. They tell you, you are the judicial officer. Look at the issues. What can you do? Remember, court has the power to amend issues. Okay, so they'll give you issues when they are vague. Okay, they tell you as a judicial officer, proceed. You see the and it's a joint scheduling memorandum, but ask yourself, ngenda gikozesa ki? Okay, you first ask yourself, okay, to be honest. Okay, what am I going to use this for? Okay, why? For you will forget that it is the duty of court to frame issues. So that literally they are telling you that exercise your duties, okay, as courts. So now we presume that the plea, everything is okay. We have gone for summons for directions after we've done the joint scheduling memorandum, and it is a success. Then what next? The matter is set down for hearing. Okay, the matter is set down for hearing. So ask yourself, what takes place in the hearing of civil matters? Just no evidence. Okay, the same story that applies the other side. They will tell you, examine me. Okay, so at that point, do you know the essence? Okay, do you know the essence? How do you adduce evidence in civil? We have by affidavit evidence and by witness statements. So can you draft a witness statement? Do you know the rules governing witness statements? Do you know the rules governing affidavit evidence? Because that's how we proceed in civil when it comes, because once a matter is set down for hearing, we are dealing with evidence. So that means at this point, you should be able to understand the effect of affidavit evidence, the effect of a witness statement. They will tell you that, for example, they'll be wanting you to make an application to cross-examine a deponent, but they will not tell you that because you are the respondent. Okay, they give you the affidavit in support of the advanced party. Okay, then they tell you the client has told you that you have reasons to believe that that affidavit is not correct. It was made by counsel without intervention of the advance party. Proceed. Because you know, once you have reasonable grounds to believe that there are falsehoods in the affidavit, you can make an application to cross-examine, okay, the deponent. Why? Those governing affidavit evidence, the affidavit should contain facts within the knowledge of the deponent. Okay, if not, they'll give you the affidavit. Down here, they'll put in paragraphs which says that I have been advised by my lawyers, okay, which advices I very believe to be true, that this and this. Then down here, instead of saying that whatever I've stated here in under is true to the best of my knowledge and belief, save for the paragraphs whose source I have disclosed. Okay, they tell you object to that evidence. Rules governing affidavits, they should contain matters within your knowledge. Anything which is not within your knowledge should be disclosed, and you disclose the source. So down here, the affidavit will show that it has contents from knowledge of a third party, but you are saying that whatever I've stated here in under, is true to the best of my knowledge and belief. So, is that knowledge yours or is for an advocate? So you object as defense counsel, okay? That it violates the rules concerning affidavit evidence, okay? They can also give you an affidavit which is not commissioned. That means that testing its relevancy, okay? Because gojja kujja ne wabisoma busomi ne wali bakikyusaamu bwe bati n'olaba pate bwegimu, okay? So now, at that very point, okay, they can also give you a witness statement when it is commissioned. A witness statement. We get a commission. Do you commission a witness statement? So they will tell you object. So what does that mean? They are testing what we call objections in evidence. Okay? They will tell you object. Nga judge wali good enough panel will panel judge. Okay, akuwerewo ruling there and then. Okay, if not, they can tell you, they can give you the witness statement. Okay, they tell you, I am the witness, kindly lead me. Okay, lead me. You have to lead the witness so that you tender in the witness statement. You go leading a counsel Nyangoma. You ask in progress. She will keep quiet. Okay, yes, those things happen. They will tell you cross-examine me or examining the chief. They will never speak. Why? But once they speak, they are looking for a remedy. What happens where the witness is keeping quiet? That witness has become. So deal with that witness. Make an application. Declare him or her a hostile witness and move on. But they will not tell you. Okay? All that happens in hearing of the suit. If not, you will enter. They tell you that you cancel for the plaintiff. Okay? The matter is coming up for final hearing. But you've been informed by the son of your client that the client has passed on in a motor accident. Okay? You are entering court like this. Can you adjourn? Okay? So now they are testing effect of death in civil matters. At what point does death affect civil proceedings? Therefore, it's coming up for final hearing. What does that mean? The final witness, who is your client, you have dead. So do you have a case now? What happens? Okay, is this criminal? Because the criminal, once the party dies, the matter also, but civil, the matter survives. Okay, the matter survives. So they are waiting for the prayer you're going to make when you are in court there and then. That's why I told you that in civil, just be creative. Think of a remedy anytime. So now imagine, client yafude oyingide mu court ngaha yowaship katumala okuzika. Okay, what remedy? Okay, so what happens? Okay, how does death affect civil matters? Okay, how does death affect civil matters? It depends at the stage. If the matter is still in the hearing, you make an application to stay the matter. The matter is stayed until appointment of a legal representative. Reason: a civil matter survives to the legal representative. Look at Order 3 of the Civil Procedure Rules. You first appoint an administrator, and then the administrator becomes the plaintiff. And if not that, okay, they can give you facts where court didn't stay that matter and it proceeded without the administrator. It is a ground of appeal. Okay. If not, they will give you facts where the plaintiff died after hearing when we are going for judgment. Does death affect the judgment? So that means we can proceed with your absentia. It is okay. Okay? So you have to just think and fix it there and then. Okay? If not, they'll give you facts, okay, where you have a witness, but the witness is not around. But this witness wishes to testify. How will you fix that? Yes. How do you fix that? It's in the civil procedure rules. You make an application for. Yes, that's what made the rules. Okay. Your witness is not around. Remember, okay, this witness has to testify. So what are you going to do? Okay. We have what we call issuance of what? It has a legal term. It has a legal term in these rules. Let me see. Issuance of this where we have here. Yes. Order 3019. You read what it says. Now I'll tell you what it says. Where the witness wants to testify, but is not around. That's a legal term. I'm forgetting the legal term, but issuance of getting the legal term. But this witness, what happens? You bring evidence in writing, but it has a legal term under these rules. Okay, you apply, and your client probably he may be out of the country, but this person can write and evidence is adduced in court. Okay.
Counsel, is it interrogatory?
Not
Counsel.
Yes.
Is it interrogatory?
Counsel. No. Okay. Say no. Okay. But I'm going to trace it. What is it?
Hello, Counsel.
It's not the one. Okay. What? That witness is around. That witness is around, counsel. Because it shall be read. Can they read when they're not around? Yes? Yes. It's called issuance of commissions. Issuance of commission. Okay? Order 28. Okay? That's what we call a commission in civil. Okay? The witness is not around, but it has commission. It will come as evidence which is commissioned. Okay? And we shall proceed with it. Okay?
Excuse me, counsel.
Okay, order 28. Okay.
Excuse me, counsel.
Yes.
Now, in the scenario where the defendant is the one who has, the plaintiff has not reported the death of the person.
Okay, now, counsel, what happens? All these remedies we are talking about, they can apply on both sides because the master, what can happen to the plaintiff can happen to the defendant, not so? Yes. Okay.
Do I have any right to object that we cannot proceed when the person is already dead?
When the person is already dead?
Yes, and the opposite side wants to proceed and he has not reported it to court. Can I object?
Yes, once they don't report to court, you object. Okay? So all you need is to think between lines. Okay? So now, if not, they can tell you, we are still hearing the matter. We are still at the hearing. Okay? They can also tell you to make submissions in the hearing. Okay? They can also tell you to make submissions. Okay? In the hearing. Yes. Okay? So, hearing is a bit technical. Okay? If not, they can tell you that counsel, you are in court. Okay? You are in court. Counsel has been making numerous adjournments. You are counsel for the defendant. The plaintiff has made another application to adjourn, to proceed. So they want you to object against the adjournment. Okay? So it is not under the rules. You ask yourself, how could you respond? Okay? They want, because this is practice. Counsel has been adjourning 4 times. I come out the 50th time to adjourn. Okay? Civil procedures are handmaids of justice. Justice delayed is justice denied. Okay? The essence of the amendment of the civil procedure rules is expeditious disposal of. We therefore invoke 98 and 33, the application to be dismissed. Okay? So whatever remedy we are looking at, make sure you know how to respond, how to apply, and how to make a ruling. Because ogenda kubeera byonna. When you look at your panelists, kuliko babaita ngoli omumanyi, typical defense counsel. Why do you think they have Sechito in land? He's always defending the Ministry of Lands. So expect him to ask you how to defend the government in land. Okay? Is Counsel Kabega on in criminal? What do you expect? He's the prominent defense counsel in criminal matters. So Musanga, Justin Nancy. Okay, he's going to ask you things concerning the defense. Okay, so genda kubebi remedy getwogerako, be the plaintiff, be the defendant, and the judicial officer. Always. Okay, that's how always can mean to treat you. Yeah. What about him? Okay. So now, okay, so the hearing has, okay, a lot of things. The hearing has a lot, okay. Some of the things are not under the law anyway, it is practice. But what you should know, whatever question comes in the Gotojimani, okay, sit, think like a lawyer, add up some good English, invoke 98 and 33 of our answer. You make a prayer, once you keep quiet, because they'll start abusing you, they start mocking you, so just speak. Okay? Just speak. I told about the guy, Counsel Bulamu was asking, okay? The guy itabimanyi. What is in order 53? Yes, the guy tried to speak, but to be honest, if you guys have heard that now, you've just laughed because you know order 53 does not. Okay, so that means just civil procedure rules. Now I'm okay. Okay, give us the names of the director in order. In order, the director of the purpose. In order, how he writes his names. How does you see? Imagine others are saying Frank Miguel Otendi. Is that the way he writes his names? Are you sure? Yes. I know Manyame. Asat Lovan. Okay. You get it. So when things get tough, all options will be available. So just pray that Allah makes a way for you. Okay? Because the civil is full of practice. Ogenda kwata rules ozade ogende wali kana ye. Because you guys are going to go with the rules. Mugenda kanga. Okay? Otwina soko entrance. Tenga location ngwega msilamu chevampadde. Sobola. Okay, ngatenga rules was genda kugasa kanka wana sena zo santi. Ngugaze n'ekitabo kya civil. Ogambo banchizeeyo. ng'ekiri munda wali practice after practice. Okay, so when you take this mode, okay, things become a bit simple. So now we presume, okay, that the hearing has come to an end. After hearing, because in the hearing, that's when you look at what called examination of witnesses. So those who are going to appear, okay, on panel, panel C of Counsel Alinda Ikanza, okay, in the aspect of that hearing, please polish your trial advocacy. Ajja kugamba cross-examine. You start your fake cross-examination, and she gets pissed when you do what is not perfect, because she is a perfectionist. Okay, you get it? They taught you the practice in the form of a moot. Okay, so she expects you to have the entire knowledge of a moot without fail on her panel. She's the kind of person who likes examining on pleadings. Okay, drafting, because I'm a moot. To be honest, I'm mugamba. Oboina answered when she's the one. Okay, Oboina answered. So when you're appearing before her, try advocacy musome omugate kusibo, you will make it. Okay, she can ask you, what are the advantages of written submissions over oral submissions? Because it happens in civil, not so. You had that week when you're doing hearings in civil. This side you had submissions in what? In trial advocacy. And she'll leave you there. Okay? So be keen. So now, after the hearing, in civil matters, we have some amendments in the civil procedure rules. If it is a land matter, land is civil, not so. What happens after hearing? Visiting locus. So that question they may not ask you. They can tell you, counsel, give us 4 developments in the civil procedure rules amendment. 4 developments in the civil procedure rules amendment. To be honest, go away to the amendment here. Ojimanyi bulungi. What new developments? Tezaliwo mweri enkadde, but they are in existence. Okay? First things first. When you are dealing with them, first appreciate the fact that the civil procedure rules amendment, the amendment was for expeditious disposal of civil suits. So whoever is appearing before Justice Sekana, Gisome, because he's one of the prominent judges who adhere to the civil procedure rules amendment. Agimanyi word by word. He's a bright judge, that I'm sure. Because you've read his judgments, his rulings. He is so emphatic on the civil procedure rules, because for him, he believes that civil procedure rules are handmaids of justice. So there should be strict adherence to these rules. Why do you think he was made the head civil? Think by mistake. He's the head of civil division, not so? You think it is by mistake? Amani. So when you appear before him, so Kosome amendment here, because he was one of the masterminds of that amendment. Okay? So you ask yourself, okay, do you know those developments? Okay? What is in order 11? A. That is 1. Okay? Yes, that is 1. Okay? Did you have dismiss of warrant of prosecution in civil? It is there. Once you've instituted a suit and take how many months without following up? It is in the civil procedure rules amendment. It wasn't there. Okay? Strict use of witness statements. Witness statements. It's in the civil procedure rules amendment. But currently, okay? Okay? We have dismiss of warrant of prosecution. Okay? Then we have summons for directions. Okay? Then we have strict use of witness statements. Use of witness statement. Then we have visiting locus in land matters. Then increased on the powers of the registrar. Order 50 was also amended. Okay, in the amendment. Then we also have abatement of suits. Okay, before abatement, okay, it was powers of the registrar. Okay, then abatement of a suit when you don't extract summons for directions. All those are developments. Okay, yes. Also, there was an introduction of an application to bring the representative suits were there, but you are not supposed to make an application first. But in the amendment, you have to first make an application to bring a representative suit. It is not automatic. All of those are amendments in the civil procedure rules amendment. So now, what happens? They will make you feel like a judge. They tell you to act on those rules. To act on those rules, they will tell you you are the presiding judge. Okay, council instituted a suit. You have checked with your clerk. It is now 7 months. No response has taken place. Proceed as the judicial officer. So for you, if you don't know that, okay, 6 months, now this is 7. You get it? But they are testing dismissal for want of prosecution. Okay, so you should. So that means you, as the judicial officer, you're going to make an order of dismissal. You start extracting an order. Okay, so now we presume that everything is okay. Okay, the hearing is a success, and you have made your submissions. Okay, orally. Make sure you know how to make submissions orally. Okay, on each and everything. Those objections we've been talking about. Objections. Okay. Talking that I don't have questions. The other book that we had last time, those questions are not good. They're lacking something. Okay. They're lacking something. But it's okay. Okay. I can formulate my questions. Okay. So now we presume at that point, okay, hearing is done. Now you have to make a judgment. So ask yourself, here are the different types of judgments. We have an ordinary judgment. Okay. We have a default judgment. We have a consent judgment, judgment on admission, judgment on notice. What else? And you have interlocutory judgments and experts. Okay. So you ask yourself, you know how to draft the judgment. Okay. You know how to draft the judgment. Okay. Or you can explain. Huh? You can explain. Okay. You can explain the judgment, but you can't draft it. Eh? Yes, you ask yourself, you know how to draft the judgment. If they tell you cancel, it's a matter of fraud. Make a judgment. Okay. So think between lines. Now we presume that judgment has been given. Okay. Whether it's a default judgment, okay, and the one is unsuccessful. So ask yourself, what if it is one, a default judgment? Okay, a default judgment. Okay, or an ex parte judgment. What remedies are available to the party that has lost? Okay? We are going for setting aside default stroke ex parte judgments. So ask yourself, you differentiate between Rule 12 and 27. Under what circumstances are you proceeding under 12 and 27? And what do you prove to proceed under those rules? Okay, so now you've seen what happens. They can give you even the ruling. Okay, they can give you the order of this of the default judgment. Never give no, it's a default judgment. Now, that judgment has been entered against your client. No, it's a default judgment. Ojja kusanga legend ajja kukola stay of execution. But you think it's a default judgment. So you yes.
27 and
That's where we are. Okay, so now we are looking at applicability. Okay, you want to set aside this default judgment, but you either set it aside under order. Which order? Okay, which order is that? Order 9, Rule 12, or Rule 27. So you should know which facts call for 27 and which facts call for 12. And you got to discern for reasons. Okay, so when you look at those two rules, okay, they look a bit the same, but they are honestly different. Okay, so let's read. Okay, Order 9, Rule 12. Okay, it says setting aside ex parte judgments. What's an ex parte judgment? Yes, what's an ex parte judgment? So you want to set aside something that you even don't know. Yes, under what circumstances can court pass an ex parte judgment? Okay, we have this question. Okay, it says, okay, you are counsel for the plaintiff. This was my question, second question in orals. You are counsel for the plaintiff, okay, in the following files. File A, you filed a suit and served the defendant. The defendant filed the WSD, you filed a reply, but every step was taken. The defendant has never appeared in court. That is file A. Then file B, you served the defendant, but the defendant has never filed a defense. What remedies are available on those files? cancel. The first file with the reason, okay, because I have to just file answer. The first file where the defendant filed the WSD, okay, all pleadings were exchanged, but on all appearances, the defendant has never appeared. Cancel. You are in court. Proceed. Why do you proceed ex parte cancel? Why do you proceed ex parte? Because I told you just by your position. We have two types of appearance. We have what we call a physical appearance and statutory. Statutory appearance is by document. Where there is no physical appearance, the matter is ex parte. Okay? Because court already has proof. So let court determine according to what is on record. That's what we call ex parte. Then a default, you have defaulted in what is required of you. You've not made physical appearance and then statutory. So that means body 1.2. So let us proceed against you because you have defaulted. When you read the case of Stop and See, okay, where court held that failure to file a defense, any party has no locus to appear in court. It is an automatic default because court has summoned you. So so that's why the summons are clear. Court shall proceed as if they even caution you in the summon. Okay, yes, this boy says to now, but okay, but your mother warned you. At the end of the day, you start crying. You don't have okay, so where you should be thinking between lines. So when you look at this, we want to read these two rules. We differentiate them. Okay, they look the same, but a bit. They have what we call a thin line. But in practice, I've never seen any lawyer who proceeds under rule 12. Never. Yeah, because it is hard, very hard to prove in rule 12. Okay, order 9 rule 12 says that setting aside ex parte judgment, where judgment has been passed pursuant to any of the preceding rules of this order. You first stop there. Pursuant to any of the preceding rules. What do they mean by preceding rules? Rules before 12. Okay, from 1 before you reach 12. Look at the different types of judgments before you reach 12. Okay, so that means if the matter is in relation to the judgments, okay, before you get to rule 12, it is set aside by, you see, this one is restricting you to particular judgments. For example, look at rule 6, it has a judgment. The judgment is a liquidated demand. So that means if it's a judgment in a liquidated demand, you set it aside under rule. Then look at 8. It has judgment in assessment of, okay, you get it. So where a ruling plan has been made in regards to assessment of damages and you are not okay with them, okay, you proceed under this. Okay, then I think so. Are those only the judgments preceding it to 12? Okay, you get it. Now, then after this, okay, before you proceed under this, okay, it also gives you another category of judgment. It says, or where judgment has been entered by a registrar in cases of order 50 of these rules. Okay, so that means also all interlocutory matters heard by the registrar. Okay, you set them aside under this. That's what we call summons for directions, because all summons for directions are handled by the registrar. So consolidation of suits, test suits, what and how. If it is passed, okay, without your presence, you set them aside under 12. Okay, so you see, 12 restricts you to only two categories: preceding rules and so kujatuka rules, but you ruling. Okay, that doesn't fall under these two. You set it aside according to parallel. Okay, so you should be able to tell buluba kuwa document yo namu always tesobola kuba ne bwoba oyagala eba kensobi ne Allah ajja kusaasira but how to respond. Okay, also basobola okugwa kunatala abakonsobi ng'olaba ka order tekalina tabbu omulamuzi yakakoze bulungi kalowooza bakakuwadde katereka. So always be keen. Okay, then let's read the other. Okay, which is the simplest to apply. 27. Okay, in any cases, rule 27. Okay, rule 27 says that in any case in which a decree is passed against the defendant, he or she may apply to the court by which the decree was passed for an order to set it aside. Okay, so on what basis? And if he or she satisfies the court that summons was not duly served. So you see, in a open any order over here already preceding over by the registrar, we don't care, provided the service was not effected. Okay, provided service was not effected. Kati bagenda kujikuwa basobola kujikuwa mu orals ng'ogira it is expert. Okay, ogirabe bulungi nnyo ruling bakugambe you cancel for the defendant, proceed. Okay, don't make any mistake. Don't even that it is on the preceding rules. Don't risk proceed under get, because this one is very clear. What are doing a service? You get it? Because you know where we started from. Service of pleadings is mandatory. Okay, simple as that. Then what other ground? Okay, and if he or she that summons were not, or that he or she was prevented by a sufficient cause for. So this one, it is not discriminative. What am I justifiable cause? Well, on a solo can't pay Wednesday. Okay, it is a sufficient cause. You see that it has what it is wide. Anything you think of can be justifiable cause. Okay, yes, the solo can't nana Ramadan sitambula. It is on judicial notice. Okay, now toka kumi. Yes, if I justify it before judicial officer, it would be a reasonable ground, because justifiable cause is a case to case. You see that this one you can even forge any reason, but 12 it should be only that. That's why lawyers, there is no lawyer who will ever proceed under 12. Never. Okay. Now let me tell you, I myself, there is a time I had a matter. It was in 2021. So I had a colleague who was contesting in a particular constituency. So I had filed the matter at land division. So unfortunately, the summons were signed. Okay, and I didn't. By the time they were signed, we had to go a campaign. So I didn't pick the summons and the pleadings. So I didn't serve. So after I picked them, okay, I picked them and I served them. Council received under protest. So what happened? Council made an application that the matter is dismissed. Okay. So I had to look for justifiable reason. Okay. So what I did, I changed the law firm. Okay, we had to put in an application for change. We changed advocates. So Kumba was still the same. So I told the council, okay, because I knew because I was battling with a big man, okay. So I said, okay, one no, just 5 causes and no J-Coleda. So I changed the law firm. So I became another lawyer from a new law firm, okay. So I was behind someone. So I told this council that I'm just 5 causes, but I call mistake of council. So this person made an application. This order was set aside on a justifiable reason of mistake of council. Then nze yagikola nenjeeterawo ne bagisetting aside. Then after I take out joint instructions in the advances. Okay, why? But we proceeded under 27 AE. Yaitekola because no, you reason. Kataha mistake of council teriko. Where could record the council they are picking up pleadings because it's serving. Here they are not serving up pleadings. It is council. Okay. The lawyer, if it is on a mistake of counsel, me they slapped me costs in that matter. Okay, because najanga nze ndiye ate nga ndinendo nenjewunzikira nenzesasule. Okay, so you get it. 27, equal right to think beyond. Some orals, when you are thinking, just go man how to create what we call a justifiable cause, because there is no that defines a justifiable cause. Death, sickness, enjalo kuluma ko bulumi. Okay, being when your relatives preparing for orals, the pressure is too high, is a justifiable. Okay, even when your boyfriend, okay, you are up country, okay, and you're lying, it is okay. Okay, so now you get it. So now when you are setting aside, just go for a justifiable cause. Don't proceed under 12. Tosobola kuyita war. Tosobola. If you can't even reason it, just katwali ngoyina ka pressure ngolimo. Munda wali ka pressure. Do they allow you guys to handle this now? Okay? Mulinda around the Thursday. Ojja kwa to keys where the two couple gate. They are organizing the rooms. Okay? Because we say examination territory. Okay? So what if you enter? No, take a microphone in the room. So they are going to stop you from accessing it. Okay? Yes? Mm-hmm.
There is a word used. In any case in which a decree is first expired, the catch word is a decree. What decree you must understand. For us, we have been proved that really expired judgment.
Yeah, it's expired because a decree comes from what?
The judgment.
Exactly.
So this one, 27 applies once. But 12 will apply like it has it, because for which they are saying that it applies on the different things 8, 6, 7.
Yes.
So the argument that this one is more flexible.
No, why this one is more flexible? It gives you time to think. Okay? It gives you time to think. And even to be a service wa mangu. Ne wali oyina okunoonya ensonga gye batakuwadde. That's why lawyers proceed under this. Because in ekigambo justifiable cause, changu y'obulamu. Okay? Okay?
It be correct to go under Rule 12.
Now, Rule 5 applies where you are making an application for court to enter that judgment. Because Rule 5 says, once you prove that you served, you get it, Court can't give you an expert judgment or a default judgment unless you prove Rule 5 that you served this party. Why? They were Rule 27 non-service. You get it? So they tell you for you to make an application to proceed ex parte or a default judgment, prove that you served. Okay? So that means you should be having an affidavit of service. Okay? But what favors is again 27, because they even cure that position because they know it is the simplest to go to never away no justifiable cause. Never proving that you served me. So what your justifiable cause? Okay? Yes. Yes, that's
Yes. When the defendant has filed WSP, it is blessed. Can I as well succeed in writing the post judgment for the WSP blessed?
that person has already entered appearance. You can't enter a default judgment. Okay? You can wait. You raise objections. Okay? Yes. So now, you sit and think, okay, where we've come from, okay? Those are remedies of the unsuccessful party. When judgment is entered against, then what about the successful party? You have judgment, your client is the successful, that takes us to execution. Okay? Execution. Now, you people, you've just done execution. Yeah? Yeah. You're going to receive questions on execution like nothing. Okay? You've just gotten done with execution. So you are likely to receive, okay? Yes? Buli question you start to work. Okay? Buli question kadashikezi. So once you enter, oyine dakika 15. Either kuita or okolachi. Okay, but everything is possible. Okay? So now we are on execution. So how do you apply for execution? Okay? So first ask yourself, okay? Because sometimes they can ask you, what are the rights of a successful party to a judgment? Okay? What are the rights? You have a right to extract a decree. You have a right to apply for execution. So ask yourself, do you know how a decree looks like? Okay? So what may happen? This guy is a funny. They won't tell you that we want you to take us to the procedure of execution. They will draft a decree. Bakuwe decree ne judgment. Ebi, bibiri. Bakugambe, you were a defense counsel in that matter. They have given you the judgment and the decree. You proceed. They want you to object on the decree. Remember, a decree has to agree with the judgment. Bagenda kuwa judgment nga orders eziri mu judgment, sizo eziri mu decree. They won't tell you that because you know the process of execution is one. After taxation, okay, and you've acquired the taxation certificate, you extract a decree and serve it to the advance party. Why? The advance party has to confirm that the decree agrees with the you are that advance party. You've been served with this decree, but what decree ne judgment? So you are waiting to ask you what is the duty of the advance party in execution. Which your rulings and in this theoretical part, but they don't ask that. They give you a decree and a judgment. Okay? They tell you you are defense counsel in that matter. Judgment, it is okay. You go to the orders down here. Okay? You look at the decree. Does the decree agree with the judgment or not? Once it does not agree, they want you to object. Okay? So just get your gambo or okay? Because okay, you get it. You say my lord, this decree violates the rules governing extraction of a decree. Okay, it is a settled principle that a decree should agree with the contents of the judgment. In the instant case, the orders that were decreed in the judgment are payment of a decretor sum of 2,500,000 shillings. However, the decree indicates that the decretor sum is 4 million, excess of this and this. This implies that the decree doesn't agree with the judgment. Okay, if not, muja kubeeramu orders endala. So olina okuba nti decree ewali full stop olina okubeerawo. Okay, so you just look at the judgment and the decree. What was decreed? Is it what is in the judgment and the decree? If not, you object. Yes, Council.
Council, I was seeking guidance on the date when it comes to decrees and judgments. Because I noticed when I was drafting my part with the extraction date from the other side up and then down. That's why I think I have the date on which I'm going. Is that the case, or the date has to be the same from up to down?
The date has to be the same, Council. The extracted date
Yes.
and the signed date. No, why? Why is it that when you look at the day, it's you who extracts it? Okay, you know that it has been extracted because by the time court endorses it, it has been agreed upon by the parties, not so? Because remember, it depends. Because in the council, to be able, okay, you serve me the decree. I agree upon it that very day. And you go to court, they endorse it that very day. Council of our day. Okay. And besides that, you can't argue on the decree that very day because you have to read the judgment in its entirety. Remember, when the judgment is being delivered, okay, in court, okay, you don't have a copy of the judgment, not so, you just hear. But for you to read it in details, you need a copy of the judgment. Okay, maybe, but some judges are good, but some of them type, okay, no from an evajikua, but talking at Gisomera, just one evankubi omupira kaspenzile waka. Okay, but then because council has cameras looking for money, okay, for ED to extract the decree there and then. Okay, but you can't agree on it and it is endorsed. Okay, so when you look at the how the work schedule is, the dates can't be the same. Okay, unless the council wali denga ne judge who are there osura na iwaka, that is possible. Ayinza okujja ne ka stamp eka ne ka seal akateeka mu motoka nakola ko, you're dealing with bail. Okay, so the presumption is, and now mark this, your workshop in execution had different two things. You had a workshop where a decree, okay, was past the time of taxation, when you already have a taxation certificate, okay, because you can be lucky, you end up always they tell you, Rashid is before you, he has this judgment. Take him through the process he should go through to enjoy the fruits of his okay. You taking Rashid through the process of execution. But when you look at the judgment, that means Rashid has not yet gone for taxation. Okay, so that means you have to start from taxation. You draft what we call the bill of costs. You extract what we call the taxation hearing notices. You serve them. You also have what we call the pre-hearing. Okay, the pre-taxation hearing with both of you. Then you go to court. Court determines after taxation, you'll get what we call a taxation certificate. Once you have the taxation certificate, it's showing you the sum of costs that you have to enjoy. So that means you're going to add the decretor sum with the costs after taxation. You get the exact amount of money you're supposed to get from this person. Then after that, you extract a decree. Then a decree, you serve it to the advance party, okay? And then after the party has agreed, okay? If they have agreed, mark this. If they don't agree, what next? You first go back and redraft. You again serve them. If they don't agree, you go back to the registrar for determination. Okay? You go back to the registrar for determination. Yeah, I'm not told you, every step will have a remedy. They will tell you where, they will give you facts. Okay? The first remedy we saw is objection for the defense counsel. Now here they will give that you have served Hajat, okay, for the first time, and she disagreed with the decree. You went back and amended. She has also disagreed. Okay, now could you amend? What remedy do you have at that point? You go to the registrar for determination because it is beyond your jurisdictions. Okay. So now we presume that everything is okay. A decree has been signed now. Okay. So after the decree has been signed, what remedy? What next? You make your application for execution. So when it comes to application for execution, what determines, okay, is the property you have, okay? So at that how have you reached consolidation? Okay, so now, okay, so applied, but when you are dealing with execution, the same thing. Think of the remedies of the judgment debtor and the remedies of a judgment creditor. Okay, they can tell you that counsel, you are counsel for the party, in this matter, you want to apply for execution, what would you do first? They are testing what we call due diligence in execution. So what type of due diligence is required before you apply for execution? When you read, when you go to Order 22 Rule 8, okay, which talks about application for execution, it sends you, because that application is in a tabular form, it gives you its contents, not so? Look at the contents of that application. One, it should contain the property. It's clear description. So now, what if you attach property that does not belong to the judgment? So they wanted to discuss what we call due diligence before execution. Okay? Because before you apply, because what is going to determine the mode, because you have to incorporate a mode in your application. So what if you go for attachment and it said Nagaya China, actually someone again Zapkamna Sina Chenina no yes. So what I'm going to attach? Okay, so to attaching yes, okay, you get it. So before you make the application for attachment, due diligence, okay, make due diligence within the jurisdictions of this court. Does this guy have property or not? If this guy has no property within the jurisdictions, what will you do? You apply and then make an application for transfer where this person has the property, because you have to attach. Okay. If this person yes has, but the properties within the jurisdictions are not sufficient, you also have to go for transfer. Okay. What happens if this person has only money? Okay, and this money is in possession of his beautiful wife. What would you do? Yes? Listen, this money. Big answer. Okay? This money is in possession of his wife. So, Cancer, you can see the wife.
You attach the wife.
Okay? Or you attach the wife. Okay? So, what happens? You know, this wife will say, I can't live without bail. So what you do, you go for arrest and detention. Okay? First make it, you did it. Never have a casa. Hey, okay, you get it. Why? That is due diligence. Once you make an application and you make a wrong procedure, is it the problem of court? Okay. Once you apply for any modes, okay, but the challenge with the law of execution, it needs to be amended. Okay, somehow, somewhere. Amani man.
After the ADC.
Okay. They have a lot of energy when they're executing. Okay, so because what determines the mode of execution? If you have, once you realize that Rashid has property which is income generating, will you go for sale and attachment? You go for receivership. Okay. If you find that Rashid has only vacant land, will you go for receivership? To receive what? Okay, you go for sale. Which type of sale? So, and once you realize that you've applied, a difference has been made, even the way how it should be executed by who? Okay. What if you made an application and attached a certificate of a bailiff who has not renewed his or her certificate? Can that bailiff execute? It's like a lawyer without a valid practicing certificate representing you. Okay. So that means that is an irregularity in the sale. So what remedy will you be having? Where there is an irregularity in the sale, what remedy will you be having? Setting aside an irregular sale. Okay. So how do you make that application? Chamber summons or notes of motion? Yes, Mr. Chamber summons. That is the backwards. Okay. So now you see where we came from after the last topic. We came from conducting a client interview. Okay. So, but there are things I want us to put emphasis on with the reasons why. Okay. We are going back. Okay. We are going to reinterpret Order 7 Rule 1. But we are going to study widely that rule. Okay. Why? In orals, there are things they always do. The way you perceive it makes life hard. Okay. Before we go back there, Aisha, Assalamu alaikum. Give us 5 modes of institution of suits. One. Yes. Yes. Then that a plaint as well. It is okay. We said 5, but let's count that one for purposes of learning. Cancel, hurry up, okay? Okay, now cancelable. Give us 8 pleadings, 8 pleadings, Yes, that's 1, 2, 3, 4. No, it's not a pleading. That is a document that accompanies pleadings. Notes of motion. You get it? Why did I ask the first question? The first question has the answers to the second, but when you look at it, you may think they are the same questions. Okay? Pleadings, these are documents that are exchanged. So it's a mode changes it from, okay? Once they ask you a mode, you just say notes of motion, okay? And what have you. But when it comes to a pleading, a notes of motion, okay, is a pleading. Why? A notes of motion is a document, okay? A procedure is called motion on notice. Okay? Yes. You read Order 52. You will see whether there is a notice of motion. Notice of motion is a pleading. So I'm correcting her also. Okay? Notice of motion is a pleading. The mode is called motion on notice. Now, we don't have a mode called chamber summons. It's called summons in. But you read these things on a daily basis. Okay? So why? A notice of motion is a pleading. Okay? That's why I was asking that question. so that you identify between a moot and a pleading. So when they ask you categories of pleadings, never what was the money? Gamba notice of motion together with an affidavit support. That's one. Ogambe affidavit in reply of a notice of motion. SOB affidavit rejoinder. It says that Ogambe plaint WSD reply to a WSD. Ezo nazo satololi mukaga ne bakusaba 10 ezo zibawa. No gamba petition, answer to a petition, a reply to an answer to a petition, counter claim, okay, a reply to a counter claim, and then a rejoinder. You get it? So we okwatemu eva mwezi satu. Okay, when you read stop and see. So now buli type ya pleading bagyogerako ne bwevamu ne bwekola ki, because always tebagenda kubuuza kintu gwe kyolabako. No. Okay, so let's open order 7 rule 1. Olaba civil yenna 90% ali mu rule eyo age emu. Okay, and that's, I want to show you how all the civil is in that. Okay, so we are going to study following that. Okay, 90% of the civil is in that. Okay, we're not going to cover the entire thing. They have been outlining it because there are those that are outlined widely, but I have reasons why I'm coming back here, because they can ask you to give them. There is someone who has asked what is the cause of action in negligence. Okay, right. There are some order 7 common different types of causes of action. Okay, now gamba pass. Now, are you sure? Don't you think you're negligent? Now they are telling him that the answer is negligence. Now gamba pass. Don't you think you're negligent here? Negligence. The answer is negligence. Cancel. Don't you think you're negligent? I don't cancel. Pass. Are you sure? Cancel. You're acting negligent. You're leaving the answers. They are telling him that the answer is, but he joked with the Holy Spirit in again. Okay? They can ask you the same thing. They can ask you, cancel. What is the cause of action in misrepresentation? It is misrepresentation. Because it was Gobochiraba one. Okay? So let's go to order 7. So now the first topic in civil is known as conducting a client interview. Okay? So what we call making what we call a checklist. Okay? So a checklist in conducting a client interview is under order 7 rule 1. Which is more. But everything you put on that checklist is an independent topic that you had to cover in civil. That's why I had a workshop on cause of action, a workshop on limitation, everything. You had to cover it after. Okay? So let's look at order 7, rule 1. So whatever is under order 7, rule 1, before you institute a suit, you should be well conversant that all those factors exist. That's what we call a client checklist. Order 7, rule 1 says particulars of a plaint. Whatever particular, okay? Why? Bagenda kugamba okuba pleadings zino nga babesinga on this. Okay? Bakugambe joinder of parties, bakuletere third party notices, but everything emanates from here. Order 7 rule 1 carrying 50% of the civil yonna bwe musomi ng'ogisome n'ogitwala time n'ogitegeera. It says particulars to be contained in the plaint. The plaint shall contain the following particulars. It uses the word shall. So what does this mean? Everything that is mentioned here is, so once they give you a plaint in orals, first look at it to see whether all this, then you're in the question. Yeah. Chances are, whenever they give you a document, they either want you to amend it or they want you to object. Okay, so let's go. A, the name of court in which the suit is brought. So get command. Okay, we have what we call jurisdictions. Okay, jurisdictions, katusoma jurisdictions. Okay, how many types of jurisdictions do we have?
Two.
One.
Geography.
Okay. I have heard of what we call original jurisdictions and appearance jurisdictions. So
those are
Katinyaga
what?
soke to Lavao. Eh? We have what we call original jurisdictions and appearance jurisdictions. Okay. Now, when it comes to original jurisdictions, each court has its original jurisdictions. Okay. Remember, Oros, Babu Zawaidi. What if they ask you, counsel, that give us circumstances under which the High Court exercises its original jurisdictions independently, when the matter should emanate from the High Court only? Okay. Okay, let's go for two only. Okay, or two only. Yes. Yeah, that's parliamentary elections. They are for the High Court only. I have answers I'm waiting for. That's what inter-country adoption. Kwa hiyo mwajisoma mu family toenza kwekwa asante terikola ki. Then another one in family. Guardianship. Why? When you look at the act, does it give the magistrate's court? It is only, you don't appeal, okay? Only go to the high, that's what we call original. Then in other circumstances, we know under what circumstances the High Court can exercise original jurisdictions. Okay, when the matter is within its council gave it, okay, not exceeding how much? Yes, the matter should originate from the High Court. Okay. Now you get it. Why I asked original and appealant? What does this mean? That when you talk about pecuniary jurisdictions, they can fall under original jurisdictions. Because the law has stated that if a matter, the subject matter is 50 million and above, the matter should emanate from the high. Isn't it original jurisdictions? Okay. So that means, to me, I already said that we have original jurisdictions, geographical and appearance jurisdictions. Okay. Because to me, I think that pecuniary jurisdictions, they fall under original jurisdictions. Never get them oros. Yeah. Okay. You get it? So that means when it comes to court, is the matter going to the High Court or the Magistrates Court? So that means a plaintiff should have a paragraph which says that the subject matter, okay, you get it? Because geographical is with the what we call the geographical jurisdictions. When they tell you draft a plaintiff, that means your plaintiff should contain a paragraph on jurisdictions, and there should be 2 paragraphs indicating the monetary value and the geographical. So that means you say that the subject matter arose, or the cause of action arose within Mukono, which is within the jurisdictions of this honorable. That's geographical. Okay. Then you said the estimated value of the suit property is 65 million, which is within Zombito Serena. Okay. So that means at this point, you should be able to deal with jurisdictions. Okay. What if they ask you, for example, they ask you, counsel, give us 4 laws that deal with jurisdictions in suit? And that question is common. Sometimes they tell you, counsel, give us 10 acts that you've been reading ever since you joined the back course in civil? 10. Yes. Okay. But they may not, okay? They have to give us all laws that deal with jurisdictions in civil. You know what I mean? The one we have what we call the High Court Circuit, okay, instrument. Okay. We have the High Court Circuit instrument that gives what we call geographical jurisdictions of the High Court. Okay. Geographical jurisdictions of the High Court. Okay. Then we have what we call the magisterial area instrument, which gives the geographical jurisdictions of the magistrate courts. Okay. Then we have the Magistrate Courts Act. Okay, the magisterial area instrument. Okay, then the Magistrate Courts Act. And then we have the big one. We have the Constitution. It talks about the original jurisdictions of the High Court. And then lastly, we have the Judicature Act. Those are the only laws that deal with jurisdictions. Okay. Okay, that deal with jurisdictions. Okay. Magisterial area instrument. So now at that point, just know how we deal with. So what happens? They can give you a plaint, okay, when it lacks jurisdictions, okay, when it lacks jurisdictions. Jurisdiction is a creature of a statute. This section uses the word shall. So what happens where you've been given a plaint which does not have jurisdictions? You are defense counsel. Now you see how you start thinking. We are changing this provision into the practical part of it. So they can give you a plaint in orals. Read the plaint. Come down here because orals jurisdiction is paragraph 8 or 9. Okay? Depending. Look at it. Have they mentioned about jurisdictions? So if they haven't mentioned about jurisdictions, what do you expect? Okay? What do you expect? It is an objection. So you'll put in a defense with a preliminary objection. Okay? Are we together? If not, you'll make an application for security for costs because this matter. Okay? Now these guys are funny. But jaji kuwa plaint bakuna application ya temporary injunction. Okay? Yes. Why? Bakugamba you are defense counsel. Okay? Object to the injunction. Why? Osome plaint nga teli muchi jurisdiction. Bagambe respond to the application for temporary injunction. What ground is that? That means we have a ground that you have filed a main suit with a likelihoodness of success. Can that matter succeed when the plaint has no jurisdictions? It's how you're using the plaint to respond to the temporary injunction. Okay? You get it? That means the main suit cannot succeed. So that means the temporary injunction is useless. They shouldn't grant it. Okay? So I've got to get but using only this. Okay? So now we are done with A. Then B, the name, description, and place of residence of the plaintiff and the address. Okay, that takes us to what we call parties. Parties. Okay. So you read B and C says here, parties. So remember, we have a defendant and the plaintiff. So that takes us to parties. Okay. Parties to a suit. Okay. The general rule is you have a right to sue whatever person you deem fit. That's the general rule. Okay. So that means if I wake up, I can sue you. Okay. just ngamba, just toina chiwankola, nae, just wanta. Okay, and I sue you. Okay, so now when it comes to parties, we have two types of parties. That is artificial and natural parties. Artificial, we deal with parties that are not humans. Okay, for example, one, we have a company. So ask yourself, because it says name and description, they will be interested in description, counsel. Description. That means you will say T&G Enterprises Limited, plaintiff. Okay, ako kamanye ja kamuka kati na description, paragraph 1. They want to describe the plaintiff. Okay, the plaintiff is, who's giving it a try? That's sorry, are you giving it a try?
Alongside Kagogobe Road, and it is managed by Rashid, who is the current manager of the company.
Who's giving it another try? Mercy. The plaintiff. Yes. You want to try? Give it a try.
Yeah. Your box number represented by.
Now, the first thing you should appreciate that they always have their law firms, not so? So when it comes to location or address, put address of the firm. So I would say that the plaintiff, okay, the plaintiff is once the company is incorporated, it becomes, you say the plaintiff is a body corporate registered under the laws of Uganda, carrying on business of, if you know their business. Okay, you get it. You've described what we want to see. Do they have capacity to sue or to be? That's what they want in description basically. Okay, is a body corporate with capacity to sue and to be sued. Then location, you say, okay, whose address for purposes of this suit shall be firm before. Okay, P.O. Box this and this, LDC Plaza, Kagugube Road. Simple as that. Okay. When is a company, that's one artificial person. Then another one is a partnership. I assure you, because they know pleading partnership. This. Okay. So now you started what is a partnership. So you have to, they will tell you to give us the parties and the description, because they are waiting for how are you going to draft the parties. Okay. So now they can tell you that counsel, assume Rashid, Aisha, Jeff, and Mercy, they carry on a business of fabrication of metals. Your client supplied them materials and they did not pay. They have a written agreement to which the client has given you. Okay. They first ask you, counsel, which mode will you proceed with? Very fast, because of all the agreement. Minimum payment of special endorsed plaint. All of our answer like this, the counsel, draft the plaint. Give us the parties and paragraph 1. Bakoma. Awo. Okay? Bakuwa facts ng'oziraba ogenda kugamba the mode. Bakulinde webert. After giving the mode, they draft it. They are looking at. So cancel. Yes. We want the parties up. Draft the parties or 20 paragraph 1. Chechibwe. You are counsel. Okay? For the plaintiff. Okay? The parties have given you are the said defendants. So give us, draft the defendants, the name, then go to paragraph 2. Because paragraph 2 describes the defendants. Counsel start.
This versus Rashid, Aisha, Jeff, and Mercy dealing as partners.
Proceed, counsel.
Paragraph 2. The defendant
Hey, you see? Hey. Okay. I gave you a trick. That demo male or more baby males. Okay. Now they want you to describe them. So that means when you are arranging them, so either the 2 male and then the 2 females. Okay. So I would say that LDC plaintiff versus Rashid, Aisha, Mercy. Okay. Then, because in practice, to take a bracket to gamba trading as metal fabrications enterprises. Then come paragraph 2. You say the defendants are males and females, adult Ugandans of sound mind. Okay? Or because you made say presumed to be of sound mind. No, defendant you presume counsel, his counsel for the plaintiff. You presume okay, you get it. So now, after that, you've given us how, but what relationship they have. Do you know the definition of a partnership? Okay, carrying on a business in common under metal fabrications enterprises. Okay. Okay. You get it? Kagan. Okay. It was also a good work drafting. Wano. You say that LDC versus Rashid, Mercy, Jeff, and Aisha trading as metal fabrications enterprises. You come to paragraph 2. Okay. The defendants are females and male adult Ugandans presumed to be of sound mind, carrying on a business in common under metal fabrications enterprises. Because you have to describe them. How would we describe a partnership? Okay. You get it? Are we together? Together. Okay. Together. Yes, counsel.
The instances when you're now dealing with partnership limited, the LLP.
You also indicate what the gist, the partnership they carry on business in. That's what we want on it. The nature of that entity, because it has no corporate personality. All they want, capacity to sue. How do you sue? That's what they want in description. If not, we are still dealing with artificial persons. The next one they'll give you when it is a scheduled corporation, KCCA. Okay? KCCA versus Rashid. Okay? versus Rashid. Okay? Assalamu alaikum. Your counsel for the plaintiff. Okay? The plaintiff is KCCA. Draft the parties and paragraph 1.
You describe it as a body corporate.
And
that is the main point that you're looking at.
You remember, corporate season zaukana. Ere associates a company incorporated under the laws of Trinity Gamba Incorporated. You say that the plaintiff is a body corporate established by an act of parliament. You get the difference. Okay? Here it is a scheduled corporation. Yes, it is a body corporate, but its corporate personality is not by a virtue of registration. So you say the plaintiff is a body corporate established by an act of parliament with the capacity to sue and to be sued. That's what differentiates the first one of a company and this one. Okay? That's the distinction. Yes, counsel. No, but it's prudent you live with the law. Hey, it's prudent you live with the law. Okay? Because counsel, those are pleadings. Okay? Members, listen. Those are pleadings. We don't include the law in a pleading. We don't add laws in pleadings. Okay? We don't include a section. Okay? So, we still have more. You can look at the local government. Okay? You look at the local government. Look at the AG. Look at commissioner and registration. Look at commissioner URA. All those are artificial entities. So get time to understand how we describe the commissioner lands, okay? Commissioner URA, how we describe the AG. Because how we describe the local government in a plains. Okay? Political parties still. Okay? Then also, please mark this. How to sue a secondary school and a primary school. Okay? How do we sue a primary school? Yes? Yes? How do they go? There is a name. Then what about okay, one has board of governors, another had board of trustees. So the primary school has board of governors. A secondary school has board of trustees. So we sue the board of trustees, but not the school. Also, a church has board of trustees.
Primary is what?
Yes. Look at the case of is it Father Cardinal Subuga versus Rubaga girls. Look at that case. You see how they describe the parties in that case of Rubaga girls. You will see how they sue secondary schools. It is in that case. Okay. Yes, counsel. Yes, they are registered as companies. Okay, but the right to sue is reserved for the boards. Okay. Also look at the case of Holmes Darling. Okay, Holmes Darling. You will see how they sued that school. Okay. So mark those things. Okay. So that's all we deal with artificial. So Jack took our grace for some parties. And ask you to kubuzewa kasitoba gamba oyagala bakuba kyavugazi. Okay, so then okay, after that let Okay, so gwewebuuze gwakugamba drafting ekimu ku ebyo cause tokuba complaint wakuba keji emu yali ya local government. Okay, so gwewebuuze if they bring the rest magam oros, because that's why I told you gwebwolabanga workshop, look at the learning, minor learning outcome to appreciate how to sue the different parties. We no longer eyo yokka eyali mu workshop no komao. Okay, now we have what we call natural persons. Okay, hey, the natural persons. When you are dealing with natural persons, the best thing I want you guys to appreciate, okay, leave alone, we want to appreciate how minors, how they defend and how they sue, persons of unsound mind. Yes, they are the same. Yeah. Yes, because it's just what this one sometimes I call it statutory. They are a breach of an act of parliament. Okay, so when you're dealing with natural persons, I want you to understand how a minor sues and how he defends. Bobo kuye plaintiff minor no bamuteekako batya. Okay, bwaba defendant bamuteekako batya, because that is key. Then you have persons declared bankrupt. Okay, they also have capacity to sue. Now assume you are in orals. Okay, they have given you facts when you are representing a minor. Remember the week where you had a cause of action of negligent cause of death? They can give you facts where all the parents died in a motor accident and it's only the minor who survived. So the minor has a right to sue, not so. Now they'll tell you, cancel, draft the plaint, give us the parties and the description. The plaintiff is a minor. Okay? Yeah. Cancel to it. The plaintiff is a minor. Yes, well, you draft the parties because the question requires you to draft. No, council, give us the parties. Just so you formulate your own facts of or assuming it veil. As council is giving us paragraph 1, she's going to give us the description.
So I formulated it.
Yes, you give us the parties. Okay, she's going to give us the description. When you look at which order talks about suing of minors, how the minors sue? Yes, order 32. Okay, shows you how minors sue and defend. They sue through. So when they tell you to draft, okay, you say parties. Okay, you say Rashid. Okay, suing through his next of friend, indicate the name. You get it? Indicate the name. Okay? Katifiri muweja, when they tell you to describe. Who's now let me tell you, who is suing? Now that's why you get it wrong. The next of order that is very clear. A minor can sue. Category that next offender you are suing. The minor sues through. Next offender doesn't sue. Yes. So you say Rashid suing through his next friend Daniel. That's the parties. Then you come to description. Okay. You come to description. Most people they describe the next of kin, but it's not. You start with the minor. You say, okay, the plaintiff is a male minor. Okay, is a male minor suing through his next of friend. Okay, a male adult Ugandan of sound mind. You get it? Okay, so olowooza oziraba zijja gwe ekintu nga bw'okiraba wano ne bakikyusa bwe bati, because you people, you had the time to read these parties and understand gwe wakuba plaint egi n'osirika. Okay, but when they are making you draft in orals, they won't make you draft what you drafted in the book. They will tell you to draft what you didn't take time to deal with. Okay, so now that very question they can change it when the minor is the defendant. Yes. Tunatuukayo. Kansile tunatuukayo. Okay. So now where the minor is a defendant, they can tell you. So now the way you write it, the plaintiff, the same way you write the defendant. But how do minors defend? So now where there is next of friend or chijao, no gamba Rashid defending through his guardian ad litem Daniel. Okay, katino jao and description. Okay, the law is very clear on how the minor defends. No, so they don't defend through next of friend. No, they defend through guardian. Yes. Okay, but even now minor time. Okay. Yes, we've said that when you look at order 32, a minor defends through a guardian. So when they tell you to draft the parties where the defendant is a minor, you don't say defending through the next of, you say Rashid defending through his guardian ad litem Daniel. Then you come down in paragraph 2, you describe the defendant. You say the defendant is a male minor. Okay, sometimes also not take away minor defending through his lawful guardian ad litem Daniel. Okay, a male adult Ugandan presumed to be of sound mind. Tukyali ku parties katebeza tunaabumalirayo obwo bwonna. Okay, that's how funny the law can be. Okay. Then what if they give you facts where the plaintiff is the person of unsound mind? The same way you draft for a minor, but the only thing, okay, this person has no, his mental status is not okay. Okay, so why do you describe? So just describe the way you did for the minor. It's the same way, because order 32 rule 5 is clear, not so that a person of unsound mind shall proceed the same way as a minor in this order. To
shock the examiners.
Okay. Then also under natural persons, we have people who have been declared bankrupt. Okay, a person has been declared bankrupt. How does he sue? You sue through a receiver. You sue through a receiver. Once you are declared bankrupt, you don't have a right to sue. You don't have capacity to contract, but you contract is through a receiver. Next time you're going to do insolvency, you'll see it. All the receipts the company, even if when the company has been declared insolvent, okay, all the receipts of the company indicate that it's acting through a receiver. So now they'll give you facts where the plaintiff has been declared. This person has no capacity to sue, but he can sue through. Now they tell you cancel, draft the parties. Yeah, the plaintiff. Okay, you indicate that Rashid suing through his lawful so and so receive. Then you come also describe, okay, that the plaintiff is a male adult Ugandan of sound mind suing through his lawful receiver, Mr. So and so. Simple. Okay. Okay. Good. Okay. Then
I don't know what is phrasing. The rest of these words.
we can describe Rashid, but by the fact that you're mentioning a receiver is automatically indicating that Rashid is bankrupt. Okay. If not that, they can give you where you are suing through a third party, what we call powers of exactly. Okay. That one, they always give you administrators and people with powers. Parties, yes, can't. A company? No. We will appreciate that the first week of study term. After no, first week of banking, get that your receivership. Yes. So what you get now? Okay. So I've said that yes. The same way things don't change. Yes. Okay. So now at this time we want to see a natural person that's suing through an agent. Okay. Council, read for us order 3 of the civil procedure rules. Order 3 of the civil procedure rules. Order 3 of the civil procedure rules. Okay, it says recognized agents. Okay, so the following agents you can sue you as a person, but through a third party. Okay, so you say appearance etc. may be in person by recognized agent or an advocate. So that means you can sue or you can defend through an agent. So this section gives you the different types of recognized agents. Okay. When you read sub-rule 2, recognized agents of the parties by whom such appearances or applications and acts may be made or done are 1. Persons holding powers of, okay, council. Then B, persons carrying on trade or business in the names of the parties, non-residents within the local limits. Okay. So what happens when you go further, also talk about administrators. So in what happens always, they give you persons with powers of, and then they give you administrators. You've seen suits by administrators, not so? Joiner powers to sue. Okay, you get it. So here you say Rashid suing through his lawful attorney Daniel. Okay, his lawful attorney Daniel. Then after that, you got describe. Okay, describe Rashid. Okay, you say that Rashid suing through his lawful attorney Daniel. That is how we deal with parties. Then after the parties, you come down, you describe, okay, that the plaintiff is a male adult Ugandan of sound mind, suing through his lawful attorney Daniel. Attached is a copy of the powers of the same thing. That's how also defend. Yes, Council.
Yes, that's an petition.
That matter is in personam. It is in personam. Okay. Mulinde okomeo. Boboli kubwangunyo. Okay. So are we together? Now, after knowing those parties, again, when it comes to parties, we have what we call joinder of parties. Okay, joinder of parties.
You don't display the exchange.
Powers attached is a copy of. So now let's go for join our parties. Let's go to order 1, rule 1, and rule 3. How we join defendants and how we join. They will give you facts, okay, where you have numerous plaintiffs and numerous defendants. So now, when it comes to joining that, when you are going to join, these are the following factors you consider. We have what we call necessary parties. We always join necessary parties or we issue a notice to third party. Okay? Simple. Okay? When you are dealing with parties, okay, we have, you've seen where you have plaintiff 1, 2, 3, 4, not so. That's what we call joinder. So, go drafting that. No bagatta, on what basis? What if they ask us, why did you join all of this? What answer would you give? Yes? What answer would you give? Okay? So let's read order 1, rule 1. It says, who may be joined as plaintiffs? All persons may be joined in one suit as plaintiffs in whom any right to relief in respect or arising out of the same act or transaction of series or acts or transactions is alleged to exist. What does that mean? Okay. Now, bwebakuwanga facts nga zirimu ab'enjawulo, bakugamba nnyo you draft the parties. Actually, ebayinza obutagikugamba ko yo bitegeera. Ne bakugamba o drafting 3, paragraph 3, which talks about the claim. Nga balina ekigambo kye banoonya 8. Because when you read order 3, rule 1, ekosa ekigambo jointly and severally. You get it? Kati bw'oba otandika paragraph 3, okay, eya plaintiff yo ojja kugamba the plaintiff's claim against the defendant severely and nga kebadonyako. Because order 3, order 1, rule 1, ekirina, okay, you sue them jointly. So that means everything you seek it jointly. Okay. So what does it? But I've said a relief you are seeking for. So we cancel under what circumstances? Okay. Because land is civil, not so. Bajakubuza cancel under what circumstances in civil? Okay. Basically, land can use the edge. In land. Okay. Land is civil, not so.
Yes.
Under what circumstances can use the edge? Okay. For compensation, where the fraudster cannot be traced.
Okay.
Why? The remedy you are seeking also emanates from fraud. Okay. You see, the relief sought, but never quality. Same applies to commissioner and registration, where it is fraud, and they are called a chapter in contention. Him. You get it? So under that, you join there. But what happens, they always give you facts where all these parties are different. They give you a natural person, they give you an artificial person, and an entity of government. Why? Description of college under 1. You said the first defendant is a male adult Ugandan presumed to be of sound mind, and the plaintiff undertakes to effect court process upon. The second defendant is an officer of government. You get it? Because they describe now the commissioner. Then you go to the AG, you describe all of them differently. Okay? Yes? They can give you the commissioner, they give you the AG and an artificial person. Okay, or a company, or they give you a natural person. Because you can't join the government with us. There are 2 different entities. So that means for what we call a description is that no vanaga. Because no gama much omuleka agamba olait oba kiipa badde sivayo munda kyokka nga akulaga ogamba okiisa asigala akulaba ate kimugezi naye nga naawe oyitiddewo kaladi. Yes, counsel. Compensation of fraud, because the government has the duty to protect the people and their properties, not so. So why do I lose property? Let government look for the fraud stakejire and compensating. Bwene mufuna nge mubanja. Because nzayinza okunema okufuna. Ne government esobola kulema kunonya muntu. Okay? You see the edge when you want compensation. Fraud is tatala bikako. Niyagula is a bona fide purchase of value. So I'm losing my property. Okay? And Article 26 says, okay, no person shall be deprived of his or her property without compensation. Government here record. Okay, so are we together? All that we are dealing with. Now, the last thing on parties is what we call issuance of a third party notice. That is, also in the age. Okay, have you ever looked at the case of Kostrako versus AG? You read the things, then no kaisa visa. Okay. Okay. So we have what we call issuance of a third party notice. We know your parties by the way. Okay. So when it comes to issuance of a third party notice, this party is a necessary party. Okay. But this person is not a party to a suit. They will give you facts, they tell you, and you cancel from the defendant. Your client has been sued for negligent cause of death via an accident. You've come to realize that motor vehicle registration number, this and this, was insured by this company comprehensively. Okay? You have realized that your client has a bad case, is likely to be slapped with a number of costs. So what remedy do you have? Okay? So you make an application for issuance of a third party notice. Court invites that third party who should compensate in such circumstances. See party to a suit, but this person has to be a party by force. So, okay, we say they give you facts. Whenever I see facts concerning insurance, babetaga third party notice. Okay, if not insurance, we have what we call subcontracting. Yeah? What happened in the case of UBC versus NBS versus UBC? Where it was 2006. Okay, UBC had the license to broadcast World Cup in Uganda. So NBS, okay, got a subcontract from. So what happened? Super Sports sued NBS. So after suing NBS, they made an application, UBC gang. Okay, so they called UBC to compensate. So UBC has Sasulachi Super Sports. Okay, because it was necessary. If an order was made when these guys are not a party to a suit, NBS are like a freedom, and the Super Sports disagree to same. Okay, so that's how, because a third category was all what we've been looking at is parties. So much international parties. Okay, in case anything happens, you have to be sober. Okay. We say the third party kasala kwa facts as an insurance. When the insurance company has to compensate, ngasi party to a suit. It's a third party notice.
Third party wagamba ati the other party has to do that.
Aba ino kujati ekimuisa ekisa third party aje defending oba talina kusasula bwalemwa nga atukolako. Yes. Let's go back to our order 7 rule 1. Okay, let's go back to our order 7 rule 1. Let us D is settled as well. Yes, D is settled. Okay, where the plaintiff or defendant is a minor or a person of unsound. That the plaintiff is a male adult, Ugandan of sound, kukava one. Then a makakanya kwa plate oba nnyonnyole buli kimu lwakimu ekiringo kidana wadi pate buli bamukolo. Tewali kiba mu plate nga tekirimu wano. Okay, negwa okola bukozi chu. Okay, so then E, E, facts constituting a cause of war. Okay, so these guys are funny. Okay, let's assume, Angel, they have asked you that what case defines the cause of action?
Auto garage versus motorcar.
What case defines the cause of action?
Auto garage versus motorcar.
What if I ask you, what case gives the components of the cause of action?
Still auto garage.
Hey, I have asked. Okay, what is the cause of action? Okay, what is the cause of action? Listen, okay. Mugenda kumpa definition downloading a cause auto garage bweberamu. Okay, that is the case that defines the cause of action. If not, debit nyefunza versus age. Okay, a cause of action, these are set of facts which when proved, okay, which when proved what happens entitles the other party to a relief. Okay, Sebagala versus KCC. Okay, or David Nyefunza versus AG. Okay, Nyefunza yalina cause of action, unlawful dismissal. Katiba anti buyagireta against AG. Yali mu military. Military pagana ne AG, that they had to determine whether he has a cause of action against, because the military has no capacity to sue and to bring, and it's an entity of government. So AG yali no do guam. Nemumonge versus AG, they first dealt with that. Okay, so now we know the definition of a cause of action, and then okay, elements of a cause of action. What they want from that, they'll give you facts against the council. There's one is a about paragraph. Wait, bunch imagine paragraph. A council draft paragraph 4. Paragraph 4, boy in a defendant, omni plaintiff for more. Paragraph 4, a very much facts constituting a cause of action. Okay, you get it. They can give you facts when you have one defendant and one plaintiff. That means your paragraph 4 automatically should be with facts constituting a cause of action. Okay, now they will give you facts that will cast draft paragraph 4. What facts constitute a cause of? But before you go there, you are required to understand all, because a question maker can give us 6 causes of action. You know, okay, 6 causes of action. And their possible defenses. So question 1, never a cause of action. Question 2, never a defenses. So whatever workshop they gave you, yalimu cause of action in dala. Okay, but they wanted you each cause of action osomere kochi defense Steve Saint over mwachiko. Okay, so let's start. To a cause of action and the possible defenses. Okay, 1, breach of contract. It emanates from what law?
Contract.
Okay. So what are the defenses in a breach of contract? Defenses. ADM, we have duress, okay, mistake of fact, okay, and frustration. Okay, we have frustration is act of God. We have frustration, okay. We have coercion, okay, misrepresentation, okay, and fraud as well. Where it was on the side of the other part that's claiming the breach. Okay, so go ebuuze bwe bakuwaako facts ezaalimu breach of contract gwe tunuulira bye wawandiikawo. Okay, tugambye the first cause of action is breach of contract. It emanates from the Contracts Act. It has defenses of 1, misrepresentation, duress, fraud, and then frustration. Okay, so go ebuuze, did you deal with that? Then another cause of action. Okay, answer. Let me repeat this question. Okay, what is the cause of action in negligence? Yes, in negligence. What's the cause of action in negligence? Okay, the answer is negligence. Okay, so now what happens? They can ask and they tell you cancel. Categories to give you answers. No, cancel. Give us fortuitous causes of action. Okay, if they can tell you cancel, give us the different causes of action in tort. So that means that we are looking at causes of action under tort. Okay, a soccer, we have trespass. Okay, we have trespass. Playing one cow. Okay, we have trespass against the person himself. Okay, we have trespass. We have negligence. We have malicious damage or malicious prosecution. Okay, we have defamation. We have false imprisonment. Okay, negligent cause of death, stroke, death as a cause of action. Kati baba we workshop a negligent cause of death. Look at all tortious causes of action. Okay, so kati bwe bakubuzibuuza olinayo mmeka. Okay, so then okay, we said we have trespass, we have negligence, malicious prosecution, defamation, false imprisonment, death as a cause of action. Kati mwe workshop yennyini eya death as a cause of action, mwalimu facts where they told you that, okay, that the person who was sitting in the position of the co-driver, okay, the person who was sitting in the position of the co-driver, okay, was jazzing with the driver. Okay, what difference is that? So the difference in tort is called contributory negligence. Okay, so the facts were there. So you have contributory negligence. Okay, then another difference, voluntary assumption of risk. Another one, we have consent. Okay, consent. Okay, then we have also act of God. Okay, so workshop bamubawa nengamalayo negwe nosalawo beko omukomya. Okay, are we together? Tukyali ku cause of action. Okay, so never botuka orals, okay, contributory negligence, okay, then voluntary assumption of risk. Okay, now when you are in orals, please, when they ask the different causes of action, never say yes. Okay, buli emu giwe independently oba wenga 10 omutima guba kakka. Okay, so now how to mention is ogiwa independently. Once you say yes causes of action oba wekubye je ngoweddeyo. Okay, so kyogera. Then another cause of action is known as unjust enrichment. Gye bawa baganda bammwe mu corporate and commercial last year. Okay, eyo yali ebasi gye baleeta mu corporate and commercial as a cause of action yali mu banking. Naye wallahi simanyi, Allah is good. That very night twatula ku auditorium nembaga muje tubeeko kye tusomayo. That night I discussed the case of Hamis Kibundu versus DTB Bank. I discussed the case of this DFCU case of Obed Tashobia versus DFCU Bank. I also discussed that because we had facts on the ongoing matter of skies. Okay, okay, for the big man, okay, okay, of the big man. You get it? So all those facts rotate around that cause of action and okay, justified enrichment. So after discussing it in entirety, we formulated the question there and then. That's how you can answer. Or two come paper. Nga yeyo. Nga badde the facts. Okay? As a Simba group of companies. Zenyini. Ne bazikolamu facts. Ne bagibawo. Number one. Nengeva mu banking or you're discussing a bank customer relationship or J or tekemu unjustifiable enrichment. Okay? No discussing facts that money had and received. Naye wawulira tagali. Okay, I saw the exam after ogenda nga toli wallahi Allah takusasidde. Era gwe look at your colleagues. Magana kwa kumax zawe za simu. Baina 12, 8 awo. Maximum I think but lucky enough in my former group media was corporate. We never meet. Okay, so why you see that cause of action? It is unpopular. The reason why they have sent it because it is ongoing. Okay, many of you mwagana okusoma case ya Hamis Kibundu versus DTB. Mutumwagala kumanya. Okay, no one has, you guys were seeing that matter of Simba group of companies on news and everywhere, but tebiva kwata keze ensonga z'abagagga. Okay, some of you made it fun. Okay, some of you are busy chatting with your boyfriends who can't even discuss the matter of Simba group of companies. And you let him ask him. So that means you are not unupdated man. Be updated. Think like rich people. You also become rich. But you think like, hey, okay, you get it. So what? Because that cause of action of unjustifiable enrichment, how does it happen? When you look at the facts of Obed Tashobia versus DFCU Bank, that is the first case where that principle was applied here in Uganda. How? Obed Tashobia, okay, received money from City Bank of Thailand via a check. So this guy was so friendly to the bank manager of DFCU Bank, okay, Masaka. So I'm going because he was dealing with this bank often, naga manager, inaka check kange kano njagala kunkola konenga kadola. So I'm here we can't. You need to have, you have an account which is a shillings account. So you need to open up a bank account, but for dollars specifically. But we don't do it here because manager like I say, like I will tell you, oh, the manager drove the guy to the main branch in Kampala. Hey, go and send a zari kwa account. Emitwalo 10 ejja dola ogimanyi. So Obedi Tashobe abamuleeta, he opened up a dollar account. So he, after that minute, after opening up the account, now take a look at check. So the bank cashed the check, let's take up account, but without carrying on due diligence. From here we are saying that Jayaga Gwenda Kweyo Zako na you're spending the entire night. Ne manager So the guy, after spending like half of the money, the bank realizes that the account had no money. Okay? Yes. The bank realized that the check okay, manager. So what happened after this guy had consumed the money? The guy could not get the money back. So they told him, you know what? Let us make it a loan or disassurance. So now, what happened? The bank decided to close the accounts. Okay, the bank closed the accounts, and they even combined them. Nefuketia emu sente zonna ne baziggyako omulundi gumu. Kati nga balinda buli ezigendako nga bazitema nga takyajja accessing. Nga just egendako obugenzi tezikola ki? N'asuwinga back for breach of bank customer relationship. Yes, court declared that the bank was negligent. N'aguwangula naye tebamuwa costs. Why? Unjustifiable enrichment. Yali ayagala kwekusanga yoki omuntu kibayita okulira mu nsobi. Okay? Because he had taken the money. Okay? And he also knows the truth that the check had bounced. They explained to him, and he's suing the bank to get also damages. They won. So zeziri to get it. So that's how the bank. So the same thing that was happening in Hamistigun. DTB gave him money because they did a syndicate loan without his consent. Now he's turning around that I'm not going to pay. The money we gave you and you utilized it to construct natural. Now you're saying you're not paying. What? How will we survive? You get it? You have something, but gwagala, okay? Question could you okay? Oh. No, Hamis Chubund applied for money from DTB Uganda, but the amount of money he wanted, DTB Uganda could not disperse the same. So they contacted DTB Kenya. Never was said in that. Never one harm. So what happened? DTB Kenya, they no so just sent the account. So again, the deductions the DTB Kenya. The loan he got from DTB Uganda. Sisasula. So that's how the matter came to court. So
why didn't DTB Kenya give this to you?
Because it's a syndicate loan. That's how syndicate loans are conducted. Okay, banking next time. Okay, but I was just expressing so that you get that cause of action. So that cause of action, that's how it happens. Okay, then we have another cause of action known as defense. Okay. Now it can happen as a cause of action or as a defense. Bank defense. Okay. Jiba basingako okuwangula naye maama waliwo bukyatubidde sijagogera because it's still ongoing. Okay. It's a breach of the duty of an advocate. I'm not allowed to comment on a matter that isn't mine, which is ongoing in court. Okay, you get it. So read about those things, you understand that cause of action. Then we have another cause of action known as fundamental breach of human rights. Sometimes it's known as violation of human rights. Movie man. Okay, look, ask those of people power. People power. Hey. Ask them. They know how they fight for freedom. Okay? Okay? You understand? Okay? Then you have another cause of action known as fraud. It is in land, basically. Fraud. Okay? Fraud, the defense is fundamental breach of right, consent. Right, you can consent to violate your human rights. You can. Okay? Webuza govayo chapas. Yagamba yakiriza bamuso wa milioni ameka. He gave the consent neta tumala akomirevi. Ay papa mwevale. Okay, we go on. Then the fifth cause of action is fraud. Okay, the defense in fraud is bona fide purchaser for value without notice. Okay. Go asoma cause of action. Go asoma mechanism. Simani. Okay. Hey. Yeah, go. You are like that. Okay. And which other cause of action we have? Okay. That's under taught. Dating, conversion, that's taught. Okay. I think those are sufficient. And if we ask yourself, what some other causes of action in mechanism? Okay. Each workshop you had was directing you to particular causes of action. Is it more line with its possible defenses? Okay. Just so many yoka. Okay. So now, how does that happen? So that means whatever cause of action we have talked about, you know how to incorporate it in a place. Okay. So how do we deal with paragraph 4? Okay. Some of our questions are video. Okay. Yes.
I have a question.
Okay.
Council, there is an oral question I saw where they were saying that the lady went to the petrol station, but she told them that she wants petrol. They instead gave her diesel. But before she left the petrol station, the station caught fire. Sorry, the car caught fire because of the mistake. And now the question is, what is the cause of action? Is it damage?
Negligence. It is negligence. Yes.
Oh.
Because skill of care.
So how
yes. Okay. So we go on.
Cancel.
It is negligence because remember, someone working at the petrol station, that person knows the danger of putting petrol where diesel operates. A question also I went to the petrol station to get fuel, but I left the engine on. Okay. And I went to the supermarket. Okay. After filling the tank, the car caught fire. Okay. Now they will tell you that I am counsel for the petrol station. This madam, okay, has sued that of negligence. So the defense would be contributory negligence. She contributed to the negligence because she left the engine on. Okay, because you never get a petrol station back like engine off. Simple as that. Okay, but it takes time to get to that. When you just look at facts and understand this is this. Okay, so now, okay, so there is what I want us to appreciate, how we draft that incorporation of these causes of action we've looked at. What you should know, okay? Whenever they tell you, create your own story, okay? That story should be in chronological flow, okay? For example, if I say that the facts, let me do for negligence, okay? So now, whenever they give you, they can say the cause of action is negligence. Draft, okay? Paragraph 4, okay? Now, bwebakugambanga paragraph 4, nga bakuwadde negligence, fraud, misrepresentation, okay? Don't even dare miss thinking of paragraph 5. Eyina okubeerako automatically, particular as bagenda kugamba okimanyi these are causes of action that need to be particularly pleaded. Kati gojja kukoma kufa kakati bana abayizi. You get it? So let's go for negligence, okay? So when you are giving the cause of action, it should be in order. I will say that at or around the 24th day of April, we boarded motor vehicle registration number this and this from So, because I'm making a story of how the driver was negligent, but Ojimua, where everything started from. So we said that we boarded from Busia heading to Kampala, okay? That before setting off, the driver notified all of us to tighten our seat belts. Okay. As we were, so you see, the driver notified us to tighten our seat belts. Okay, which we all did. That as we were approaching Mbale, the driver untied his seat belt. Yenga yate yachitugambye. Okay. He also went ahead and switched on the radio. Ajako seat belt, kati akola ki, atekako radio. Enavuga kitegeeza emmotoka asigaza omukono gutya gumu. Okay? In a heated argument on the radio station concerning the win of Liverpool and Arsenal. Okay? The driver shouted on the top of his voice and even left the steering and said, I swear upon the living God. Okay? And he raised his hands. What does this mean? Steering seat belt because of the argument. Okay? You see? It is at this point that he realized that the car was running 120 kilometers per hour. Nga kalimi kaguddeyo dda. Takute steering, that's the seat belt, avuga speed. Okay? When we reached Mbale Trading Center, okay, he was driving at a very terrible speed and he did not even take the chance to brake. Yasigala atwala butwazi naye ayita mu trading center mubaamu abantu, not so? That the car lost control and knocked. Okay? The nearby and went to the nearby shop. where the plaintiff's mother and brother were injured and eventually died. Okay, go ojiraba. Okay, and then after I'm going to particulars of negligence. Zeziriwa. Okay. Okay. Particulars of negligence. 1, okay, high speed. 2, non-tightening the seat belt, leaving the steering, okay, when he raised his hands, okay, driving on a terrible speed, not braking when he's entering a trading. Okay, so cause of action. Now imagine, okay, you have your friend, she's judging you, how she made the love of her life. You girl, can you imagine? On the day of wedding, so I realized that this guy was good. But I met him when we were in school. Okay? Instead of starting when she met him, okay? Next story about Nyuma. Remember, lawyers are storytellers. So when they tell you to deal with paragraph 4, make sure the cause of action or demand. Because if you don't know the cause of action, you can't incorporate facts. In orals, most cases, they don't give you facts. You generate your own. Or generating facts, I swear you won't be able to incorporate it. Okay? Yes. Okay? So now, let's proceed with our order 7. Rule 1. Teach you again. Okay? Then, jurisdiction Sidimaze. Then we are interested in B. The rest was cause. Okay? In D, the relief which the plaintiff claims. How? The relief which the plaintiff claims. So that takes us to what we call remedies in civil. Okay? Have you ever gone to court without seeking for a remedy? Go away, okay? Why will you touch it, to be honest? Okay, over against the callers. Okay, so now the remedy you seek depends on the cause of action as well. Okay, the remedy you seek. Okay, now let's assume the cause of action is negligence. What remedies are you seeking for? Damages. How do you get to damages? We first get what we call declaratory orders. You say a declaration that the second defendant was negligent. Negligent. What follows? Okay, then you come for general damages. How are you going to feel when your son or daughter is dead? Okay, how much money can you receive? Okay, okay, the money you've spent, the dreams. Mommy, doctor, who is going to tell you such words? That is what called general damages. Okay, then after general damages, we said it is negligent cause of death, is a cause of action. So you didn't spend money. Okay, you go for special damages. But remember, once you have special damages, that's why chances are high. Plaint which are negligent cause of death in full. Particulars negligence, then after nautical particulars of special damages. Okay? Yes. Why? Special damages should be specifically pleaded and specifically proved. So, receipt, that's a cost. A coffin, that's a cost. An ambulance, that is a cost. Treating the dead body, it is a cost. Burial preparations, it is a cost. So all those costs, you specify them, you go for what you call special damages. Then, haven't you paid the lawyer to institute the suit? Then costs of the suit. So the remedy you are seeking for depends. Okay? Ojasanga olinga ataddemu permanent injunction. Let me tell you. Okay, temporary injunction. Okay, so understand under what circumstances do you go for injunctions? Okay, injunctions are in breach of contract, fraud, and we have trespass and defamation. But now you can't go for a temporary injunction when you don't have a permanent injunction in your plaintiff. You get it? Why? Bagenda jikuanga plaintiff tell him permanent injunction. Kati baku application ya temporary injunction bagamba oli defense counsel. Kati lwaki ne bawali na mbite nimfika tojeta. You get it? So mark that. So that means at that point, we expect you to look at the different remedies, the different injunctions, types of damages, okay? Under what circumstances each and every damage should be dealt with, okay? So, have we done justice on civil court? Okay, is civil hard? Huh? Anyone with a question bank for us?
Civil is too hard. I have not even started to understand. Rashid.
Yes.
I think I need a special PMC session. I understand better when I'm at PMC.
My neighbor will come and bench me.
Yeah. Aha.
It's an offer.
Question 1 goes to Council Rebecca. Okay. Question 1 goes to Council Rebecca. You are, okay, members, listen, okay. You are junior counsel holding brief in a summary suit. Opposite counsel raises a PO that the person who signed the affidavit is a stranger to the content herein. Proceed. That was a question from Counsel Mayanji. Okay. You are junior counsel holding brief, okay, in a summary suit. Opposite counsel raises a criminal objection that the affidavit is deposed by a stranger. Proceed. You are in court, okay? A PO has been raised. What do they want? Respond to the PO. Simple love. Tumusomye, okay? Owuliranga alina kyotegeddemu. Naye question, eh? Hey, but the question, bagikubuuza, wallahi ngolatuka mwaka wewe. That's why I told you, civil, you need practice and the law doesn't make you pass. So we go on. Counsel Rebecca, you are junior counsel in a summary suit holding brief. Opposite counsel has raised the defense, has raised the PO that the affidavit was deposed by a stranger to the facts therein. Proceed. Okay. Shall I say the pass?
First of all, an affidavit is supposed to be commissioned by the commissioner of, and therefore it is. I applied that this no.
You are responding. It's your affidavit.
I applied for amendment without legal.
Hey, you see? Okay. I have the answer. Can someone to try?
What I'm thinking is wrong.
Okay, give it to us. We shall rectify the same.
But, since the the contents of the affidavit in the first place must be well known to the person carrying the affidavit. Now, since it was not commissioned, that
It is commissioned. The commission. The objection is, okay, that the affidavit was deposed by a stranger. That's only more court. They want you to proceed. That's why the question has proceed. Civil, you know, who was among. Okay. Okay. Let's break this question like this. Have you ever seen an affidavit? Give me the contents of paragraph 1. Okay. That I so and so care of this and this, well conversant with the facts herein. I depend that the applicant in this matter, I depend that affidavit in that capacity. Again, a paragraph is okay, that whatever herein is true, the best of my knowledge and belief save for. Okay, then look at the commissioning here. Okay, it is. So, how can someone who has done those 3 things become an alien to the affidavit? So you have to respond, confirming the court that this is the affidavit of my client. Okay, you're not examining. You're responding to that. So, to me, I'll say, okay, because whatever what money provision, you get a call. Okay, we want to add moot way. We've been looking at rules governing affidavit evidence. Okay, rule 19. So you can say, my lord, we are alive to the provisions of rule 19 of the civil procedure. Okay, order 19 of the civil procedure rules, which sets out the rules governing affidavit evidence. My lord, the nature of affidavit evidence is already commissioned, which indicates that it is an oath. The deponent herein is a Catholic, which she stated in. Okay, because remember, once you say deponent, it automatically means you are a Catholic or a Christian, whatever. If you say affirmant, you are belong to the Islamic faith. Okay, you get it. So from that, okay, my lord, it is evident, okay, that the deponent owned the contents of by saying that I. It is therefore clear that the deponent is not a stranger. Okay, she is well conversant with the facts of. Simple as that. So I pray that the objection is overruled. Because where your duty is to make sure that the objection is not upheld. Where you are upholding after that, we're just striking her off. Okay. Okay. Of order 19. Okay. So you get it. That is affidavit of service. This is an affidavit in summary suit. Affidavit evidence, affidavit of service. Hey, okay. Question of that's the challenge in the civil. Osobola okuddayo n'obisoma byonna era n'obiddamu naye n'okwata question zino ng'ola tolina munookaabira bwerere. Yes, but I told you right from the start that civil is practice. Another question, okay? Counsel Daniel, this is yours. Okay? Your clients were representing themselves. Okay, they later instruct you and you present them from the hearing. Opposing counsel raises a PO that the plaintiff does not contain particulars of listen, okay? Your clients were representing themselves, okay? They're representing themselves, okay? Now you have gotten instructions to represent them in the hearing. Okay, you get it. Okay, opposite counsel raises a PO that the plaintiff doesn't disclose particulars of fraud. You also see it that it does not contain it. Counsel, proceed. You are in courts. Higher verse. Hey, Kasivo Kaulira. Tugende mas.
Naira Shide.
Yes. Yes, counsel.
You're to speed, Nekasiv.
Counsel, can I try?
Now, counsel, first wait. Whenever, when you read which one talks about amendment of pleadings? Okay. Okay. 19. It has at any stage. The word at any stage means before judgment. Now, the challenge you have, there is a PO, okay? And that PO can disorganize the entire suit, okay? Now, proceed, counsel. What the hint on how to proceed? Okay?
Counsel,
there is a PO. Work on the PO first. Because if you don't deal with the PO first, my dear, bagenda Google. Because the order 7 says shall, it is mandatory. Where you tell him move. Kasajikira chenakola chenakunyumizako a justifiable cause. Okay? Okay. You respond, you say, because once the PO is raised, okay? Because now the challenge, I've told you, whenever they say proceed, they don't need the answer. They want act of advocacy. You are in court. Here my wording. You will say, my lord, I concede to the application, to the objection. You agree with the objection. Okay. However, my lord, I have just received instructions in this matter, and I have not yet gotten the entire file subject to perusal. I wish to bring it to the attention of this honorable court that I have also notified myself with the missing contents. However, in the interest of justice and equity, I pray that this honorable court grants me leave to amend the claims. Okay? Also, kanojawo chiri. Okay, that's what I told you, that the challenge we have, practice is different from the law. Civil, okay? That's the challenge. Okay? I told you whenever they ask me a question, before they get done. So you've seen, your counsel has just received instructions. You can't proceed on defective pleadings. Regulation 12, ekukwata, or a negligent advocate. Okay? Keko Kasivo. Okay? Recent. Okay. Okay. Give 2 grounds of objecting a defense filed under summary suit. Give 2 grounds to object, okay, a defense filed under summary suit. Members, listen. I repeat the question. It is okay even if you buy time. Let me even come closer. Okay? Give 2 grounds of objecting a defense filed under summary suit. Give 2 grounds of objecting a defense filed under a summary suit. Yes?
Counsel, can I try?
I've ever had what we call conditional defenses. These are defenses we file upon fulfilling a particular condition. So a defense under Order 36 is a conditional. You only, okay? You only file a defense where a court has granted you. So the presumption is they want grounds for objecting an application for leave to appear, but those are the grounds they want. So how do you object an application for leave to appear and defend? Sibo bono yingirayo ojja kuterera. Sorry. Okay, so how do you object? One, that this guy has no justifiable cause. This person has no defense whatsoever. Okay. What are the grounds you base on to apply for leave to appear and defend? That one, you have a justifiable defense. 2, it has a likelihoodness of success. That is the grounds the now is objecting up. Okay? Simple as that. Simple mulava. Simple chintobo chimani. Ne question is a practice. Chechaula. Jovana bagambye. Question ya civil ne criminal. Ojivayo ngokaka sandiche. Ekubye. Okay. Another question. Okay. Another question. Ndani wa principle. Kano kako. Okay. What's our people power? Okay. Yeah. Sisobola musonyiwa. So, okay, your counsel for Muhammad Segirinya in a suit of defamation. Okay, the defendant dies along the way. What happens? Okay. Now, what do manipulate if we are far? Okay, that the defendant yakosechi out to get him back. Hey, hey, you are counsel. Okay, you are counsel for the defendant who is Segirinya in the suit of defamation. Okay, Segirinya dies. Proceed. What happens? Okay, Segirinya dies. Hey.
The suit abates. The suit abates.
Counsel. Okay. This is the cause of action which hits in personam. So the suit abates.
The suit abates.
Okay. This is the only cause of action that does not survive death. Right. Civil procedure.
Civil manya na yena ako nange kamanyi.
Counsel Gibbs in a year. Okay. Counsel Gibbs, this is yours.
Nakugabe simanyi civil na shoot.
Yes. Try this out. Okay. You are a judge. You are a judge. You have made a ruling. You have dismissed an application for temporary injunction. Give us the basis for your dismissal. You are a judge, okay? You are a judge, okay? You have made a ruling dismissing application for temporary injunction. Give us the basis of your dismissal. Members, listen, is giving us his answer. Okay?
The defendant has failed, the plaintiff has failed to prove a prima facie case. The plaintiff has failed to show that he will suffer irreparable damage if the temporary injunction is not granted.
Okay,
The balance
Counsel,
of
thank you.
convenience.
Counsel,
The
it is
balance of
okay.
convenience.
Stop there. Counsel, tokalemera ko nnyo kati.
Am I on the
Okay,
right track?
Kati gojja kuba olinze question bakugambe. Give us the grounds upon which a temporary injunction can be granted. Agikyuse. Agambe, give us the grounds of dismissal of a temporary injunction. The same answers, but language changes. That the applicant has failed to prove. Share. Okay. Yeah. Yes, Professor, this is yours. I want you to represent your new president. Yeah. These guys have the youngest president in the world. Guy has swag. Eh? So now, Counsel, this is yours. Okay. Members, let's all listen to this. You are the registrar. The plaintiff has filed a suit under Order 36 for a claim of 60 million shillings. The defendant has filed a counterclaim stating it's 50. Proceed.
It's become a contentious.
Famous mistake. Okay. You are the registrar. Okay. You are, listen, members. Question you naka step gamba whatever, because they are giving you the duty of the registrar. The registrar is an officer of court. Okay. Is an officer of court. So I want you to act as a registrar. Your language should be changed. Okay? It says, you are the registrar. The plaintiff has filed a suit under Order 36 for a claim of 60 million. The defendant has filed a counterclaim stating it is 50 million. Proceed.
Order 36.
You are the registrar.
Yes, Order 36 actually gave a condition where there is no contentious matter.
Yes.
So in a circumstance where the defendant has actually given that the contentious issue is 50, then it's either the plaintiff agree with that 50, otherwise it goes into a plaintiff.
Okay. Now, you see, have you ever heard of the text of judgment? Ever heard of a judgment on admission? You get it? So, as a registrar, I'll enter judgment on admission on 50 million shillings. Then I refer the matter back for hearing for the 10 million. That is the answer. Because the 10 million has become now contentious. So we first get judgment in respect of the 50. Okay? You get it? So then the 10 becomes a contentious matter. Then desire. Defense. Okay? This guy has admitted 50 million. Okay? Set of Mudene by Mwensoti. Yes. Okay? Yes. This one is for Counsel Joan. Okay? This one is for Counsel Joan. Yeah. Do you know third party proceedings? That's how the question is here. Do you know third party proceedings? What are they? Members, listen. What are they? Yeah. Okay. Council Jamil. Assalamu alaikum. Do you know third-party proceedings? Huh? And you have to go back home. Did you? Do you know third-party proceedings? Okay. You know third-party proceedings? Huh? Okay. Angende no wokumutasa. Okay. Do you know third-party proceedings? Okay. What are they?
Third-party proceedings which require a person who is not a party to the original suit to be brought for the interest claimed.
Okay. When are they applicable, and how do you move with the third party?
Third-party proceedings are applicable where the defendant puts it to court that part of his liability is to be contributed by a third party, and they are brought by someone in chamber.
Okay, to proceed. Okay, he's correct. Those are the answers. Okay, third party proceedings. These are proceedings where a party who is not initially party to a suit is brought to the attention of court. Then where do they apply? In circumstances where a defendant has been sued and is supposed to indemnify, but the third party should contribute to the same. It is by way of chamber. Now, Jeff.
Yes.
Kanokako.
Okay.
Okay. You are the judge. Okay. And you have passed judgment against the plaintiff in a suit for defamation. Okay. You are a judge and have passed judgment for the plaintiff in the suit of defamation. Okay. You have passed judgment in favor of the plaintiff in defamation. Okay. Yes. Yes. What grounds do you base on your judgment? Okay. You are the judge. You have passed judgment in favor of the plaintiff in a suit of defamation. Okay. What are the grounds for your judgment?
The grounds, one, that the person made a defamatory statement.
Yes, that's one.
The defamatory statement was intended to injure the reputation.
That's two.
The eyes of the right-thinking person.
Hey.
In the society.
Okay. Now, okay. Okay, you get it. Kasanija. Kanokako. Bas. You are the court process server of land division. Okay, you've been given summons to serve against Afande Mwesige, who is in Somalia. Proceed and serve. Yes.
I serve on the CDF.
Yes. Listen, it says you are the court process server, okay, of land division. You've been given summons to effect service on Afande Mwesige, who is in Somalia. Proceed and serve. It is okay, but he's a soldier.
Right, Rashid?
Yes, yes.
I don't know the answer, but I would serve on the PS Minister of Defense or on the CDF, Command in Chief of the UPDF.
It is okay.
Assuming I
You're
am
going
in
to harmonize
oral,
the
that's the
position.
answer I would give.
Okay, Council. Someone with the rules. Council, waiting for your answer. Council, you serve who? Okay, have you ever read Order 5 Burundi? Yes? Okay. Rule 20 what? Okay, so it is Rule 20. Service, okay, on public officers and soldiers. You serve the commandant in chief. Okay. Yes. It's Order 5 Rule 20. And you're going to talk about outside jurisdictions, but on Makugame is a soldier. There is a reason. Okay. Hey, Council can welcome. Members, listen. Council is answering this one. Okay.
Rashid.
Yes, Council.
How are we resolved that UPDF thing? I missed the point.
You serve to the officer in command of that officer. It is under Order 5 Rule 20. Okay.
But if I went with PS or CDF, I would fail completely, or I can get some money.
No, CDF would work because you may argue that that gentleman is the CDF is his commandant.
Yes.
Yes, because it requires the commandant of that soldier. It's the one you serve. Okay.
Council Rashid,
Yes, Council.
you serve on the mission coordinator.
Okay. Because, but when you, because Council is making a clarification that you serve on the mission coordinator, but the mission coordinator under Rule 20 is the commandant of that battalion that went for that force. Okay.
Exactly.
Exactly. Okay. You say civil are practical. Category na very civil procedural zizo. Okay. So Council, praise God. Happy Easter. May say we didn't wish you good Easter. Okay. A client is in your chambers with summons served yesterday, but we are extracted on the 17th of December, 2022. Yes, they are defective summons. That's, you've identified the problem. So how do you deal with the defective summons? Okay, you've identified the problem. Okay, this what is the essence of summons? Yes. Okay. So have you filed a defense? So that means the client is before you to file, but on expired. Now proceed from there. You are the lawyer for the client. Okay. Yes. Yes. Okay. They are yes. So you're going to sit with the defective summon counsel. So why has the client come before you? So the answer is you make an application for extension of time. That's what they are looking for. How to deal with these are summons they served your client. The client did not file. Okay, so he had to file a defense. Yo lazima yakola ki? So they are in a counsel. So failure to have counsel is sufficient to gain the mass. Yeah. Extension, okay. Time is out completely. Enlargement, you still have some few days left, but you can't work within those days. Okay, cancel Anita, you can't miss as well. Okay, it says, okay, draft summons to file a defense. They file, okay. You see now, like this question, yeah, about a what day option. Literally, you know, Kubes, someone's in an ordinary suit and someone's in a special endorsed plane. Okay, the Republic of Uganda, okay, in the High Court of Uganda at Kampala, this and this civil division, civil suit number this and this of 2023, Rashid versus Vincent. Okay, summons to file a defense. Take note that the plaintiff has instituted a suit against you. Okay, you are hereby required to file a defense within 15 days from the date of receiving this summons, failure of which this honorable court shall proceed against you as if you have filed the same. Dated at Kampala, this 24th day of this and this, okay, be given under my hand and seal to just track. That's an ordinary. Okay, failure of which court will proceed against. That means court can proceed under a default judgment or experts. Then they also require to draft summons in a special endorsed plaint. Ozina. Next format game is say one take notes that, okay, the plaintiff has instituted a suit against you under order 36 of these rules. You are hereby required to file okay, you are hereby required to make an application for leave to appear and defend within 10 days. Failure of which court shall enter judgment. This one.
Counsel, I have a small question to be helped, Counsel, before you proceed.
Okay, Counsel, after answering that question, I have a question for you. Okay.
Counsel, I have not appreciated that the service of summons when now suppose the defendant is served and has not complied, deliberately refuses. Which step do I take?
Counsel, I've not heard your question well.
Where the defendant deliberately refuses to comply to file in his defense, what must I do? The applicant, the plaintiff. Counsel, you are lost. I don't know whether my question was not clear. I don't know.